Can you explain the difference between Ladybird deed and revocable trust? Do we need both? So a Ladybird deed is a particular type of land deed that's recognized by Florida, Michigan, Vermont, West Virginia, and Texas. So only a few states recognize this deed. And it's a way to basically add a beneficiary to your property. So what is a deed first and foremost? A deed is a document that shows who the owner of a particular piece of real property, real estate is. And typically deeds come into play oftentimes when somebody is selling a property. So you have the person who's actually selling their property called the grantor, and they sign this deed giving the rights to the property, the title, the ownership to another person or company or trust, and that's called the grantee. So that deed is just a document evidencing the ownership of the property, who owns the property. So with a Ladybird deed, it is a very specialized or particular type of deed where it shows who the current owner of the property is, the person who has all the current rights in the property. We call that the life estate tenant typically in a Ladybird deed. So they have the property for life. They can do whatever they want with the property while they're alive. So if they choose to sell it, they can sell it. If they want to take out an additional mortgage or reverse mortgage, or they want to rent it, they can do whatever they want because they're still the owner. But this very specialized deed will list a beneficiary. That's called a remainderman. So it is someone who will own the property immediately upon the death of the life estate tenant or the present owner. Why this is important is because by doing that, it's much like listing a beneficiary on an account, like a life insurance policy or a bank account or an investment account. When you list a beneficiary, the beneficiary immediately owns that account or that asset upon your passing. And a Ladybird deed is exactly the same. You're listing someone or multiple people or a trust as an example, and that person or that trust would then immediately own the property upon your passing, upon the current property owner's passing. Now, a trust is an agreement, usually between you as the person creating the trust and you as the person managing the trust, that's called the trustee, regarding what you want to have happen to your assets while you're alive and after you pass away. And with the trust, you're able to actually presently, while you're alive, transfer assets into your trust. Again, typically you are controlling them as the trustee or the manager of the trust if you're doing this for probate avoidance. So you transfer assets into the trust while you're alive so that they avoid the probate process. So the main reason for setting up a revocable trust, which is the type of trust that you can make as many changes to as you want during your lifetime. The main purpose in setting that up is so your assets do not have to go through the court process called probate when you pass away. You're basically depositing them into a trust while you're alive so that the manager after you, the successor trustee, can simply distribute those assets to whomever you want them to go to if they're still owned by your trust when you pass away, meaning if you didn't sell them or get rid of them while you were alive. So they're essentially two totally different types of instruments. The deed on the one hand is simply a piece of paper which says who owns property. The trust, on the other hand, is a more lengthy agreement that is going to describe what you want to have happen to all of your assets, not just real property, but all of your assets while you're alive and after you pass away. Both the Ladybird deed and the trust have this special feature of probate avoidance. So the Ladybird deed is much like a payable on death designation or any type of beneficiary designation, where since you're listing a beneficiary on the deed, it thereby avoids probate. The trust document itself is what lists the beneficiaries in your trust agreement or your revocable trust, and that's what allows those beneficiaries to then take control of your assets, how you have it written in the trust agreement after you pass away. So they're essentially two different things. And the question, do we need both? It depends. It really does depend. Sometimes I'll have clients come into the office. The only valuable asset they have is a home, and they may just have one beneficiary, one person who they want to receive the home. They have no one else. In that instance, we will sometimes do a Ladybird deed for just the property, the real property, list their beneficiary, and if they maybe have a bank account or a couple other assets, we can put beneficiaries on those as well. So that does happen. But more often, I have people come into my office who have lots of assets and have multiple beneficiaries, so more than one person who they want to receive their assets upon their passing. In that instance, we normally would set up a revocable trust so we can ensure that all their assets, not just their real property, can avoid probate by going through their trust. But we may deposit their real property in their trust using a Ladybird deed for a couple reasons. One, it's nice sometimes to keep you as the owner on your property, especially if you have a mortgage, so it can avoid any confusion with the banks. It also doesn't change up anything with title insurance if you're remaining the owner on your property. So oftentimes I'll have clients, rather than wanting to put real property directly into their trust when they have a trust, which is an option, they would rather do a Ladybird deed. And we do this a lot, where we have our clients who are the owners of their home listed again as the owners of their home on the Ladybird deed. They're now going to be called the life estate tenants, right? And they own their home the same as they do now. But upon their passing, we list the trust as the beneficiary, or the trust that we created. So that means when they pass away, the property goes directly into their revocable trust, and it does not have to go through probate. So that's an example of how these things can be used together. So to answer the question, sometimes the Ladybird deed alone is enough. Sometimes it isn't, which is why it's important to talk to a skilled estate planning attorney about your specific needs, because every situation is different. So you want to talk to somebody who is very well aware of the reasons for using both a Ladybird deed and a trust, or using them together in order to find out what's right for you. And if you are in Florida and you have this as a question, you can definitely contact our office, because we can help with this, or any of your estate planning, elder law, or probate needs if you have them. The link to atCause Law Office is in my bio, so please reach out.